Hello CLAT aspirants. Welcome back to iQuanta's CLAT YouTube channel. How are you guys doing? What's happening? How is everyone doing? Yes, tell me. How is everyone doing? Good evening, Anu. How are you? Yes, tell me. How are you? Good? Nice. Let's wait for 2-3 minutes for everyone to join in and then we'll begin. Right? Hello. Hello, Nilaya. How are you? So Anu and Nilaya, like, did you guys give CLAT exam this year? For just attempt sake, did you? Yes. Anirudh, nice. How much did you score? Yeah, if you guys are still in 11th, then you could have just given it for the sake of just like a practice. You could God have an idea, right? Yes, just for the experience, right, Anirudh? Let's begin with the session. Let's begin with the passage 1, right? Today, it will be fully an application class. What all we have learned in the past 3 days, we will apply those to the passages, right? So, this is the passage 1, right? That's a good score, Anirudh. Even after giving it for just for experience, good score, pretty good score. Right. So, passage number 1. related to law of torts first. In the law of torts, one defense available to a defendant is the defense of voluntary non-fit injuria, right? This is something that we learned in day before yesterday's class, right? What is non-fit injuria? In which the plaintiff is not entitled to damages because he consents to the act which has caused injury to him. जिसने खुद ने consent दिया हो उस injury के लिए, that particular person is not entitled to get damages. Right? In torts, there is a duty on every person to do acts with reasonable care in order to avoid any harm which may occur due to their failure of taking such care. So what are they saying? That there is a duty on every person कि आप हर एक एक्ट रीजनेबल केयर से करोगे, एंड अगर आप उस एक्ट को रीजनेबल केयर से नहीं कर पाते हो, देन you have breached that duty. That this in general, but there are certain exceptions which are allowed in these cases called defenses to tort. अगर by chance आपसे कुछ ऐसा act हो भी जाए which you had no intention to do, right? जिसमें आपका intention नहीं था, still you can take a defense in tort, right? You can claim for the defenses, right? This in general, but there are certain exceptions, this I've learned. Under these defenses, a defendant can escape liability, and voluntary non-fit injuria is also one such defense which is available to the defendant, right? So here they have told you a purpose of the general defenses, that why general defenses are taken into picture, right? For the application of this defense, there are certain essential elements or conditions which must be fulfilled to prevent liability, right? We already know what are the essentials. The plaintiff has the knowledge of the risk, and that the plaintiff with this knowledge has voluntarily agreed to suffer the harm. तो सबसे पहला essential element क्या है कि plaintiff को पता है that there is a risk involved, right? The plaintiff knows the risk is there and still he takes the risk, right? Voluntarily he agrees to take the risk, right? Thus, whenever the plaintiff is aware of the possibility of the harm which is likely to be caused by an act, and when he still accepts to do that, then that therefore agrees to suffer the injury, a defendant is relieved of his liability. अगर आपने खुद ने consent कर दिया, if you consented for the harm, for your own harm, then that particular case में the defendant would not be liable. This is what we learned day before yesterday. If you remember, this is what we learned, right? Voluntary non-fit injuria. Continuation of the passage says, but only having knowledge about the risk is not enough for the application of this defense. It is known as santai non-fit injuria, which means that mere knowledge does not mean consent to the risk. They are saying कि mere consent, they are saying that mere knowledge is not sufficient. सिर्फ पता होना that yes, there can be risk involved, that is not only the essential condition. सिर्फ यही नहीं है, not only the essential condition, right? Thus, having a knowledge is a partial fulfillment. It is one of the conditions. Right? In the cases where the defendant is taking the defense, the burden of proof is on him to show that the plaintiff had full knowledge of the act and consented to the risk involved in the act. Consent होना जरूरी है. Consent should be there, right? So, not only the knowledge, but the consent is also necessary. The consented to that risk. And the defendant has to show that the plaintiff was also aware to the extent of the risk, that how much risk is involved, वो भी plaintiff को पता था. How much risk is involved, that also the plaintiff knew. ये भी आपको prove करना पड़ेगा. For such a defense, the consent of the defendant is not required to be expressly given, and even by his conduct, his consent can be taken. But when a plaintiff gives the consent for an act, such consent should be free from any coercion, fraud, or any other such means by which the free consent can be affected. In such cases, the consent of a person is not free. The defendant cannot claim this defense to escape liability, and he will be held liable for the damage caused. Tell me, is the passage clear? Hello Ashu, how are you? Is the passage clear? Tell me everyone. Is the passage clear? Tell me. Let's solve the questions. Right. The first question. Priya has a scooty whose brakes do not work. Disha, knowing about the conditions of the scooty, still agrees for a ride with Priya driving it. Due to the failure of the brakes, they both sustain injuries in an accident. Disha filed a suit against Priya. Can Disha claim compensation for the same? Can Disha claim compensation for the same? Disha is the plaintiff, Priya is the defendant, right? Tell me. First question in front of your screens. What would be the correct answer? Option number. Option, everyone. Answers. Answers, everyone. Why nobody is answering? What do you think? What will be the right option? Disha can claim compensation for the same as Disha suffered injuries because of Priya. Cannot be the answer. Because she knew the condition of the scooty. Disha cannot claim compensation for the same as she agreed for the ride even after knowing about the brake failure. And yes, that is where option B becomes your right answer. Question number 2. Ram, working on Sham's construction site, had a crane which carried rocks over the workers' heads. Ram had also complained Sham about the risk. One day, Ram was injured because of the rocks falling on him. Ram sued Sham for the damages. Decide. Advait, we are doing an application class. We are solving the passages today. They're not related to any specific topic, but we are doing the passages today. Ram, working on Sham's construction site, had a crane which carried rocks over the workers' heads. Ram had also complained Sham about the risk. One day, Ram was injured because of the rocks falling on him. Ram sued for the damages. Decide. Sham will be held liable as Ram has already complained about the risk which can cause injury. Okay, this can be an option. Sham will not be held liable as Ram had to take care of his own keeping in mind risk involved. Of course not, because he has already complained about the thing. Sham will be held liable as the incident happened on the construction site. No. Sham won't be liable as Ram continued to work irrespective of the risk involved. Yes, this can be an option. इसको रख सकते हैं. But इस option को हम तब रखते जब we would have seen कि राम ने उस चीज के लिए कंप्लेंट ना किया हो. राम ने कंप्लेंट किया था and that is where A becomes your correct answer. He complained, right? कंप्लेंट हुआ था. Fine. Ram, working on Sham's construction site, had a crane which carried rocks over. Oh, sorry, the question. Yes. Over workers' heads. Ram had also complained Sham about the risk. One day, Ram was injured because of the rocks falling on him. Ram sued Sham for the damages. Decide. No, this is something. Just a second. I am really sorry, there is some mistake with the passages, right? Wait, let us solve some other passage. The questions has been misinterpreted in the last passage, right? So let's do another passage and I'll bring up the questions till then and then we'll solve those passages, right? Any legal framework that regulates trade, business and private transactions is built on contracts. According to their enforceability, contracts are divided into three categories under the Indian Contract Act of 1872: valid, void and voidable. A contract is considered legitimate if it meets all the requirements such as competent parties, free consent, authorized consideration, right? Passage from Law of Contracts. Right? A void contract, on the other hand, is one that is legally unenforceable from the start because it is unlawful, impossible, or lacks necessary components. For example, a wager or an agreement to commit a crime are essentially null and void. Right? On the other hand, unless one party decides to repudiate it because of the certain circumstances, such as coercion, fraud, or deception during its formation, a voidable contract remains valid and enforceable. Right? This we saw. The contract becomes enforceable if the party that feels wronged does not use their right to revoke it within a fair amount of time. A significant difference is seen in the effects of invalidity. A void contract has no legal force behind it. It cannot be enforced at all. But a voidable contract may gain validity if the person who was wronged affirms it. अगर जिसके साथ गलत हुआ था वो confirmation दे दे या consent दे दे तो voidable contract को valid में turn out किया जा सकता है. Right? Arpit Mishra, hello. Hi. Consider a scenario where A threatens B and makes him sell his property. Although this contract is initially voidable at B's discretion, it can become enforceable if B later ratifies it voluntarily. B अगर ये बोल दे कि चलो ठीक है, with my consent I want to sell the property. अगर वो consent दे दे तो क्या वो valid contract में turn नहीं हो जाएगा? It will turn into a valid contract, right? However, if A and B decides to smuggle goods, the contract is null and enforceable because it is against public policy. ये तो starting से ही null and void है ना, because it is a illegal contract. Right? Similarly, a commitment made without anticipating reciprocation, for example, does not constitute legitimate contract since it lacks mutual consideration. Free consent is essential to a legally binding contract according to the court's constant rulings. Consent is only deemed free if it is not impacted by fraud, deception, undue influence, coercion, or error. Analyzing contractual conflicts and their resolutions thus requires an understanding of these classifications and their ramifications. Right? First question. Based on the passage, which of the following agreement is void? Which of the following agreement is void? A agrees to sell his car to B for 1 lakh but later refuses to deliver the car. A promised to pay B 5,000 if it rains tomorrow. A forces B to sign a contract to sell his land under threat. A enters into a contract with B which B later resigns due to fraud. Which of the following is void? Void, not voidable. Void they are asking you. voidable नहीं पूछ रहे हैं, void पूछ रहे हैं. ध्यान से जवाब देना. D. A agrees to sell his car to B for 1 lakh but later refuses to deliver the car. ठीक है? This is something, this was initially a valid one, but then there is a breach of contract, right? In this particular case. Second one is A promises to pay B 5,000 if it rains tomorrow. Can you know that it will be rain tomorrow or not? Can you know that? Will it be raining tomorrow or not? So this can be an option for the answer. Because you don't know whether will it rain tomorrow or not. How can you make a contract for a certain thing which can be unpredictable, right? A forces B to sign a contract to sell his land under threat. Under threat, that means coercion. It is a voidable one, right? A enters into a contract with B which B later resigns due to fraud. Again, voidable. तो क्या ऑप्शन बचा? Option B. B would be the correct answer. Which of the following scenario represents a voidable contract? Voidable contract क्या होगा? A and B enter into a contract to smuggle diamonds. A and minor promises to pay B 10,000. A is coerced into selling his property to B but later agrees to sell voluntarily. A enters into a contract with B where B was misled about the terms but chooses to continue with it. What do you think? What will be the answer? D. Voidable बताना है. A and B enter into a contract to smuggle diamonds. Void. A minor promises to pay B 10,000. Agreement with a minor. Void again. A is coerced into selling his property to B but later agrees to sell voluntarily. Voidable. Coercion है. A enters into a contract with B where B was misled about the terms but chooses to continue with it. Valid बन गया. C would be the correct answer. Hi ma'am, what rank did you get in CLAT? I gave CLAT 7 years back, probably 8 years. And at that time my rank was 463, general category. I was getting Nalsar, Hyderabad. Fine. Next question. Which statement is true regarding void contracts? Right? They can be enforced if both parties agree to perform their obligations. They are legally binding only after ratification. They are unenforceable from the beginning. They become valid with the consent of the aggrieved party. Yeah. Because at that time, the pattern was for direct questions. So the cutoff didn't go very high. Plus the reservation at women category. Void contract, Advait. Void contract. Understand the question again. Because I didn't want to go to the, I didn't want to go very far away from my family. That is why. They didn't allow me to. That is the thing. D. Oh my God. See, they are saying what is true regarding void contracts. They can be enforced if both the parties agree to perform their obligations. Cannot be the case. Void agreement is something which is not enforceable. Even if parties agree to, it is not enforceable, right? They are legally binding only after ratification. No. They can become valid with the consent of the aggrieved party. ये voidable case में होता है, void में नहीं. Voidable के case में होता है. They are unenforceable from the beginning. Yes. C would be the correct answer. समझ आया? C. Is the question clear? If a person signs a contract due to misrepresentation, which of the following is correct? The contract is void ab initio. The contract is voidable at the option of the party misled. The contract is automatically cancelled. The misled party cannot rescind the contract. Yeah, there were almost 50 to 60 questions that came directly from our marathons. Yes, fourth question. If a person signs a contract due to misrepresentation, which of the following is correct? The contract is void, the contract is voidable, it is automatically cancelled, the party cannot rescind the contract. C. The contract is automatically cancelled. Okay. Some of you are saying B. The contract is voidable at the option of the party misled. Okay. Any other answers? The correct answer to this question would be B. The contract is voidable at the option of the party misled. मैंने आपको बताया था misrepresentation के केस में the answer will be voidable. Right? Which of the following is an essential element of a valid contract? Essential element of a valid contract. A lawful object and free consent, mutual promises even without consideration, agreement made under coercion, consent obtained through fraud. Answers, everyone? Very good. A lawful object and a lawful consent. And that is where option A would be the correct one. Valid essential condition for a contract. A would be the correct answer. Passage 3. A valid contract requires a lawful object, free consent, competent parties and consideration. Mutual promises without consideration are not enforceable unless they meet exceptions under Indian law, such as Section 25 of the Indian Contract Act. Options C and D indicate voidable contracts due to defective consent. An essential component of an agreement's legal enforceability under Indian contract law is consideration. According to Section 2D of the Indian Contract Act of 1872, consideration is defined as a valuable gift or promise made by one party in return for another's pledge. But not every kind of consideration is legitimate. For instance, a promise without any consideration is void unless it falls under certain exceptions, such as agreements made out of natural love and affection between close relatives, a promise to compensate for voluntarily services, or a promise to pay a time-barred debt. Furthermore, consideration must be lawful, meaning it cannot involve acts prohibited by law, fraud, or harm to others. So what are they saying? That there should be a lawful consideration, and if the consideration is not there, then the particular contract is void. Right? If the consideration is not there. But there are certain exceptions. Even when the consideration is not there, the contract would be valid. When it is made out of natural love and affection between close relatives, a promise to compensate for voluntary services, or a promise to pay a time-barred debt. Let's examine a particular instance. For 5 lakhs, A consent to sell B his automobile. Both parties provide something of value in this transaction. A gives the car to B and B pays the agreed upon amount. So there is a legitimate consideration. Conversely, the agreement is void and devoid of consideration if A pledges to sell B his car in exchange for nothing. Right? अगर आप अपनी कार सेल कर रहे हो तो the other party cannot expect कि वो आपको कुछ भी ना दे. There should be exchange between both the parties. Right? That is called as consideration. Right? Consideration can be past, present or future, but it must be genuine and not illusory, according to another important criteria. For instance, there is no legitimate consideration for a previous voluntary services if C pledges to pay D 50,000 for a service that D has already rendered willingly and without prior request. Right? अगर आपने किसी के लिए कोई एक्ट पहले कर दिया और आपने बोला कि मैंने वो अपने मन से किया है, वॉलंटरीली किया है, तो आप बाद में जाके उसका पैसा नहीं मांग सकते. राइट? You cannot ask money after that. Furthermore, consideration must proceed at the promiser's request. Since it was not done at F's request, E's voluntarily cleaning of F's garden without F's request and subsequent demand for payment does not qualify as valid consideration. These guidelines guarantee that agreements are based on fairness, enforceable pledges, and reciprocal duties. Right? The passage is clear? Everyone? Is the passage clear? Fine. Let's move forward to the questions. Why is consideration essential for a valid contract under Indian law? Basic common sense question. Batao. Why is consideration essential for a valid contract under Indian law? It guarantees performance of the contract. Okay, this can be an answer. It ensures fairness between the parties. ठीक है. This can also be an answer. It provides something of value to support the promise. Okay, this can also be an answer. It prevents the contract from being voidable. No. अब इन तीनों में से we have to choose a best option, right? It guarantees performance of the contract. Performance तो anyhow होगा, right? It provides something of a value to support the promise. Yes. क्योंकि जब तक एक कॉन्ट्रैक्ट की एक वैल्यू नहीं लगेगी तो उस चीज को सपोर्ट करने के लिए देयर वुड नॉट बी अ सब्सटैंटिव वैल्यू एंड दैट इज व्हाई द कंसिडरेशन इज नेसेसरी एंड सी बिकम्स योर राइट आंसर. If A agrees to sell his car B for 5 lakhs but later refuses to deliver the car, can B enforce the contract? Can B enforce the contract? First option, yes, because valid consideration exists in the form of payment. No, because the transfer of ownership has not occurred. No, because B must first deliver the money. Yes, because it is promise made on the natural love and affection. What do you think? Yes, absolutely correct. A becomes your right answer because valid consideration exists in the form of payment. Right? Which of the following is an example of agreement without consideration that is valid? A agrees to gift his house to his friend. A promises to pay 10,000 to B for a loan repaid 2 years ago. A promises to compensate B for voluntarily services done without A's requests. A promises to pay 15,000 to his brother out of natural love and affection, documented in writing. What do you think will be the correct answer for question number 3? Which option? Yes, option D becomes your right answer. A promises to pay 15,000 to his brother out of natural love and affection. जब आप natural love and affection में कोई चीज करते हो तो उसके लिए consideration is not necessary, and if it is documented in writing then it is a valid contract, right? Yes, it comes under fiduciary relationship. If E cleans F's garden without F's request and later demands payment, why is E not entitled to claim consideration? If E cleans F's garden without F's request and later demands payment, why is E not entitled to claim consideration? Cleaning a garden is not a lawful act. F must have requested the act for it to qualify as consideration. Past consideration is invalid under Indian law. Consideration must always be in monetary terms. Answer. Answer. Yes, B is correct. F must have requested the act for it to qualify as consideration. Mutually आना चाहिए, both sides से, right? Fifth, which of the following would be considered past consideration? Past consideration कौन सा होगा? A promises to pay 20,000 for a service D performed 2 months ago at A's request. A promises to compensate B for voluntarily services performed without A's request. A agrees to pay C 10,000 for work that C is currently performing. A promises to deliver goods to B in the future, which payment upon delivery. Answers would be considered as a past consideration. Yes, Advait. A is correct. A promised to pay 20,000 for a service D performed 2 months ago at A's request. Past में there has been an act done and the consideration is being paid now. So this was a application class that how you need to apply the concepts on the passages. Tell me, any doubts? Any sort of thing? Any doubts? Anything? Any questions do you have related to your preparation or any such sort of thing? Any doubts? Fine, guys. So then I'll see you tomorrow. Tomorrow I'll not see you. Tomorrow we have another live session that is for logical reasoning. Mr. Rohan Raj would be taking that session. Trust me, it will be a very, very beneficial session for you guys. Tomorrow 4:30 p.m. Right? And then till then I'll see you in the next video. If you have any such problems related to the batch details, or if you guys are something, you're looking for the resources where you want to like move forward with the CLAT preparation for 2026, iQuanta's batch has been launched, right? And you can find all the details on our website, www.iquanta.in/CLAT. Apart from that, there would be a calling number in the description box where you can just call for all the details, right? And till then, I'll be there with all the videos that you need to plan for your strategy and everything. I'll be coming up with many more videos, strategy and everything, right? And you must attend the logical reasoning session tomorrow. If you have any other doubts, you can just ping us up on the WhatsApp numbers as well. You guys have the WhatsApp communities as well. The link, if you are not in the WhatsApp community, then that way is also you're missing out on something. You must be there so that you can access the benefits to the free resources as well. Until then, I'll see you in the next video, in the next session, and bye-bye till then. Thank you, everyone.